everyone. Welcome to the Bill of Rights Institute AP Government Content Review webinar. If you are on our skills webinar and got kicked off, we're having some technical difficulties, but we will happily make sure we make up everything tomorrow. We're really happy to have you here tonight to help you prepare for the upcoming AP Government and Politics tests. Tonight's focus is specifically on the Judicial Branch. I'm your BRI host, Liz Evans, and I'm the Regional Programs Manager here at BRI. And I taught AP Gov for 6 years, so I'm going to be monitoring the chat and answering as many questions as I can. Joining me tonight, a very familiar face around here, Paul Sargent from Hershey, Pennsylvania, who has taught AP Gov for 15 years. We're happy to have him back this year to lead our review session. So I'm going to hand it over to you, Paul.
All right. Well, thanks, Liz. So welcome, everybody. Tonight, we're going to be going over the Judicial Branch. Buckle your seatbelts, get yourselves ready, and let's learn about this branch of government. Let me just pull this up for you, my slideshow, and we'll get this started. So yeah, this is the session 4 of 9 sessions, so we're almost halfway done here. And tonight we'll be looking at the Judicial Branch. Tonight, as part of the 2021 AP US Government and Politics Prep webinar. So if you've been paying attention the last couple of nights, if you've been with us, then you'll see that this is the same big idea that we've been dealing with for the past couple of nights. Now, this comes from the College Board, and this is the big idea for all of Unit 2. So this covers the legislative branch, the executive branch, the bureaucracy, and the judicial branch. So the big idea is this: because power is widely distributed and checks prevent one branch from usurping powers from the others, institutional actors are in the position where they must both compete and cooperate in order to govern. So we've talked about the last couple nights, wide distribution of powers, separation of powers in the Constitution, laid out an executive branch, a legislative branch, and a judicial branch, all of which have their own parts of the system. The legislative branch makes the laws, the executive branch implements or carries out those laws, and then the judicial branch is in charge of interpreting those laws. And we'll find out what that means tonight. But really, by distributing power and setting up checks and balances, you try and set up a system whereby one branch of government doesn't get too all-powerful. And so it really does bring in the whole democratic process, competition and cooperation needing to be pulled together to govern. All right. So here's our enduring understanding for tonight. The design of the judicial branch protects the Supreme Court's independence as a branch of government, and the emergence and use of judicial review remains a powerful judicial practice. So judicial review is going to be very important to understanding the judicial branch, because it is really the power the judicial branch has. But the way it's designed, it also preserves the independence. And it's important to understand that in an independent judiciary, which is not elected by the people, is an important part of the setup of the American governmental system. So let's start off with a little bit about the job. What is it all about here? Well, there are 9 justices on the Supreme Court. Why are there 9? Well, it's a good number. It's odd, which is good if you have a controversial decision, you don't have a tie. And also it makes it so the Supreme Court isn't too large. But this number is set by Congress. So there is a possibility at any point that the number could be raised, the number could be lowered. 9 is just kind of like a nice number. In fact, a couple of congressmen currently have in the works a bill to try and increase the number of justices to 13. Probably won't go anywhere, but it has been introduced. Now, unlike jobs for the judicial branch or for the legislative branch and for the executive branch, there are no constitutional qualifications at all to be a member of the Supreme Court. None whatsoever. No age requirement, no citizenship requirement, no residency requirement. Those are the things which we had when we looked at the other 2 branches of government. There are no constitutional qualifications whatsoever. And to make this, a little bit more intense, these are lifetime terms. So when people are placed on the Supreme Court or on any federal court, they have those jobs until they choose to leave them or until they die, whichever comes first. Now, they definitely do need to be confirmed by the Senate. So if you're sitting there saying like, wow, can you imagine we have a branch of government that is unelected with no constitutional qualifications whatsoever and lifetime terms? Theoretically, you could put a 5-year-old kid on the Supreme Court bench, and that person could serve on there for 90 years. Yes, it's true, but the Senate confirmation process is in place to make sure that no one who is unqualified gets onto the courts. So where does the judicial branch get its power? All right. Well, the main power of the judicial branch is a thing called judicial review. And this is the power of the court to determine the constitutionality of laws. In other words, the court's job, at least part of it, is to look at the laws which are written both by states and by the federal government, and if they're challenged, decide whether those laws are in violation of constitutional principles. Now, this requires them to do some interpretation. How do you interpret the law which is written? How do you interpret the Constitution as it's written? And the interpretations of those things are where we get wildly different Supreme Court opinions. Article 3 of the Constitution is where the judicial branch is created. It's the shortest of the articles, of the first 3 articles, which deal with the branches of government. It isn't very long at all, but it does create a Supreme Court, and it gives Congress the power to create any other courts that are needed. Now, another source of judicial power comes from Federalist 78. And we're going to talk about this in a second, but remember, if you will, that during the ratification of the Constitution, the Federalist Papers were written in order to justify why the new Constitution should be ratified, why the system of government that the Constitution represented would be a beneficial thing for America at the time. And then Marbury versus Madison in 1803, a foundational Supreme Court case, which I'm going to talk to you a little bit more about in a minute. All right, first, Federalist 78, because this sets up sort of the ideological background of the court system. This is a foundational document. So I'm hoping that during the course of your year studying AP US government, that you have taken a close look at Federalist number 78. If you haven't, it would be a good idea to do so, because there's only a set number of foundational documents, and knowing them is really important. So in Federalist number 78, this is a justification of the court system of the judicial branch as being an independent, unelected branch of government. All right, because there were real fears. I mean, think about it from an anti-federalist standpoint. These are lifetime terms. They're unelected. There's no qualifications. Like, what in the world? This thing could run rampant. The judicial branch could be making whatever decisions they want to for as long as they want to. And boy, this just seems like too much power in the federal government. Well, in Federalist number 78, the argument is made that the judiciary would actually be the weakest branch. In other words, it's not needed to be elected. It's not needed to have a whole lot of controls on it, because it is, of the 3 branches, absolutely the weakest. And the reason for this is because the judicial branch has no power of the sword or the purse. Okay, so think about this. The power of the sword is the power to make something happen, the power to create action. And the executive branch of government has that. The executive branch is the one that carries out these laws, makes them work. The power of the purse, the power of money, is held by the legislative branch, and Congress has that. So if you think about it, without the power of sword or purse, the judicial branch can't enforce any of their rulings, nor can they fund any of their rulings. So that leaves it at the mercy of the other branches of government. Now, Federalist number 78 also described the power of judicial review. However, judicial review is not written into the Constitution, so it actually needed to be interpreted in order for the judicial branch to have that power. Well, that came along in the court case of Marbury versus Madison. This is one of your required Supreme Court cases. So again, I hope that you spent some time learning a little bit about this case. Its big importance is that it confirmed the power of the courts to determine the constitutionality of laws. It said that yes, the Supreme Court and the court system itself has the power to decide whether a law violates the Constitution or not. And this is really the judiciary's main check on other branches. So in a system of checks and balances, and especially if you're asked about checks and balances on the AP exam, when it comes to the judicial branch, it really is judicial review. They have the ability, they have the power over the legislative branch to find one of their laws unconstitutional. It also has the power over the executive branch to find some executive actions unconstitutional. So those will nullify those actions, at least theoretically, and that gives the court all the power that it has. Now, when it comes to making decisions, the court system has been a little bit all over the place. But basically, what they work off of is a system of precedent. Okay, so those decisions which have been made in the past are going to continue to be made. This allows the Supreme Court to make decisions that the rest of the lower courts, the district courts, the appellate courts, that they can follow as they rule on similar cases. So if, for example, you have a case like the one here, Brown versus Board of Education, which had to do with school segregation, once the Supreme Court passed down that ruling that separate is not equal, then it was given to the lower courts to take care of many other cases which also dealt with school segregation that didn't need to come all the way up to the Supreme Court. So precedent is a really important idea in the way the courts work. And they work off of the doctrine of what's called stare decisis. And stare decisis is a fancy Latin term, but it's a doctrine to let the precedent stand unless there's a compelling reason to overturn the precedents. Now, the Brown versus Board of Education case was actually a case in which stare decisis didn't hold true, because the Supreme Court in 1954 looked back at an 1896 decision which created a segregated society and said, at least in education, that doesn't hold, that there actually was a need to overturn the precedent. And it doesn't happen a lot, but it certainly does happen. And the way the court system works, it's possible that it could happen at any point. Which brings us to ideological changes, because you see, we're always having new people placed onto the Supreme Court, especially, but also the entire court system. And presidents are the ones who are in charge of appointing justices. If you recall from last night, one of the formal powers of the president is to make appointments to certain positions in the federal government. And judicial appointments are just that. Now, when presidents appoint justices, they look for individuals who share their ideology. So conservative presidents are going to nominate conservative judges. Liberal presidents are going to nominate liberal judges. As those appointments begin to take hold inside the judicial system, that can change the ideological balance on the court. This is being the Supreme Court in particular. So, and a great example of this is what we have currently. Over the last 4 years, President Trump was able to nominate and have confirmed 3 new Supreme Court justices. So a full third of the Supreme Court, which remember has 9 justices on it, a full third of the Supreme Court is made up of Trump appointees. And those appointments made it so that the makeup of the court has shifted to a conservative court system, so that we have 6 conservative justices and 3 liberal justices currently. Now, that really changes the way things go down, because as you have a change in ideology, and keep in mind, before Trump, this was not a conservative leaning court, the changes in ideology can lead to overturning precedents. So some of the things which 5, 6 years ago might not have been questioned, who might have been very solidly inside of stare decisis, well, now maybe those things are open to be challenged because there's a conservative lean to the court, which will be more open to hearing cases which had previously not been in question. These are the things, though. You never can predict what the Supreme Court's going to do. But that ideological change is really, really important. And if Supreme Courts overturn old precedents, that creates new precedents. And those new precedents are then going to be used throughout the court system in order to judge lots of similar cases. So really, the ideological changes on the bench resulting from the president can lead to massive changes in the way society functions because of the changing interpretations of the Constitution and what it means. Well, all of this shifting has really brought up some questions throughout the history of the United States about the legitimacy of the court. Look, sometimes court decisions are unpopular, okay? Sometimes they are very unpopular for a majority of America. More times they're unpopular with the people who don't agree with the court decisions, you know? But every time there's a group of people who don't agree with the court decisions, there comes this discussion about what the legitimacy of the court is. Remember, these are unelected officials serving lifetime terms, so they are not accountable to the people at all who are making these big decisions. But keep in mind, even in controversial court decisions, like the decision in Roe v. Wade, which you see a picture of here, which made abortion legal in the United States for all intents and purposes, there are ways to change court decisions that are out there. First of all, judicial appointments. As I just talked about, if the judicial ideology of the court changes, then that can change the way that different precedents are seen. So judicial appointments can change court decisions, but legislation can also do that. So if the court decides that a law is unconstitutional, Congress can go back and they can write a new law which accomplishes the same thing, but gets rid of the unconstitutional part of this. And understand, and this is really important when we talk about legislation, the process of making laws and the process of seeing a law through the court system is a very, very, very slow process. So it's entirely possible that a piece of legislation that's passed won't be challenged in the Supreme Court for 5, maybe 10, maybe 15 years. So these, now some things can be fast tracked, but these things take a long time. So passing legislation can be really effective. And of course, the implementation of the court decision can change the way that the court decision works. If the bureaucracy, maybe at the behest of the president, drags their heels, implements things slowly, that can really affect the court decisions. You know, the court case of Brown versus Board of Education was heard in 1954, saying that schools should be desegregated. But by 1972, only 0.5% of schools around the country had been integrated. So it really didn't take hold very quickly at all. Slow implementation. Now, if we're looking at government as a way to make policy, you have to understand that the federal court system also has its own role here. And really, there are two kind of views of what the court system does in terms of policymaking. One is the idea of judicial activism. Activist judges kind of see themselves as a third policymaking branch of government. Not all the time, but certainly it's there when needed. And they can use court decisions in order to make or change policy. So activist decisions are ones which broadly interpret the Constitution and which use the power of the court to change things that maybe the executive branch or the legislative branch are unwilling to change, or maybe they're unable to change. Whereas on the other side, judicial restraint is the belief that the decisions should really only be on constitutionality. Here, the courts really take more of a referee rule, and they rule on things which are appealed, not trying to change the outcome of policy, but simply to make a determination for that particular case and that particular moment. So in order to like illustrate this, let me give you the story here of Ernesto Miranda, okay? You've all heard of your Miranda rights. You've watched TV shows, cop shows, all that, where they've read the Miranda rights. You have the right to remain silent. You have the right to an attorney, or you have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. If you can't afford one, one will be appointed to you. You're familiar with this. So the ruling in Ernesto Miranda's case, or I guess the question, I should start with that. The question in his case was, if you have an individual who confesses to a crime, but was never told that he had the Fifth Amendment right to remain silent, not to self-incriminate, can that testimony be used against him in a court of law? Now, a judge or a court that's practicing judicial restraint perhaps would have made a decision based on Ernesto Miranda's case only, saying that in this case where he did give a confession, but he and his lawyer contended that he did not know he had the right to remain silent, that in his case, his case should be retried without using his confession as evidence, because in that particular case, he was, the cops took advantage of him, perhaps, they had him confess to something without telling him that he didn't have to confess to something. That would have been sort of a ruling that exercised judicial restraint. But the actual ruling in the Supreme Court case was an activist ruling, which said that not only did Ernesto Miranda's case have to be sent back to a court to be retried without his confession, but that all individuals had to be informed of their right to remain silent before they were questioned by police. And if they were not informed of those rights, then what they said could not be used against them in court. So you see the difference. One is a very specific ruling. One is a very broad ruling. The restraint ruling doesn't change policy too much. The activism ruling changes policy a lot and has police reading rights to people when they're getting arrested. Now, the court is, of course, a very powerful branch of government. Its power of judicial review is it's very powerful. But what sort of checks exist on the power of the court? We see how the court can check other branches of government. Well, as I've said, congressional legislation can change court decisions. If a court overturns a law, finds it unconstitutional, Congress can pass another law accomplishing the same thing, but trying to get around the unconstitutional parts of those things. There are also constitutional amendments. Now, this is a much more difficult path to go than congressional legislation, but if the Supreme Court says something is unconstitutional, there's no more solid way to get around that than to put it right into the Constitution. Many times, constitutional amendments have been brought up to try and overturn the flag burning case in Texas v. Johnson, which said that burning an American flag is a protected form of speech. And none of these constitutional amendments have gotten that far. But if a constitutional amendment is made prohibiting flag burning, then all of a sudden it's not a protected form of speech. It's in the Constitution saying that it's illegal. All right, so constitutional amendments are a way around this. Judicial appointments obviously are a check on the court because they can change the makeup of the court and change its ideology. It's a more long-term solution to something, but it certainly works. And lack of implementation is obviously very important. There was an old case back during the presidency of Andrew Jackson, where Jackson wanted to remove Native American tribes to the Oklahoma Territory from Georgia. This was challenged in court. And when it came to the Supreme Court said that Jackson did not have the authority to remove these people outside of an existing state. That was an overreach of his authority. He couldn't do it. And Jackson very famously said, well, let the court come and enforce that then, and went ahead and removed those people. And Congress can change court jurisdiction. This can work on a whole lot of different levels. Courts at lower levels, they can change what types of cases they hear. They can change what areas of cases they hear. They can create new courts. They can change sort of the power of the court system through its jurisdiction. So where I want to go here is I want to just take a moment. Now, tomorrow night, we're going to get into civil liberties, and I know tonight was a little bit short, but I want to sort of bring together the three branches of government before we go. All right, so we've had all three of these branches, and if you'll bear with me, let me just roll back to our big idea, okay? Because power is widely distributed between three branches, the legislative branch that makes the laws, the executive branch that implements those laws, and the judicial branch which interprets those laws, and checks prevent one branch from usurping powers from the others, please understand the checks that branches have on other branches, okay? The checks that the legislative branch has on other branches, number one, its ability to make laws. Number two, its power of the purse is really important. And there are others. I'm just sort of highlighting the main ones. The executive branch has the check of implementation on the other two branches is a big one, but it also has veto power over the legislative branch. And then the judicial branch has that judicial review power. This prevents one branch from usurping powers from the others. The other branches are checking the power of the other branches. So institutional actors, those people who work in government, are in the position where they must both compete and cooperate in order to govern. Competition between parties, cooperation between branches of government, and between members of the same party come together to make our public policy. And really the big thing is this: if we have a system which promotes both competition and cooperation, in which lawmaking, policymaking is a slow, deliberate process, then the ideal is that on the back end, we're going to come out with the best possible policy. Does that always work? No, of course not. This is an imperfect system run by imperfect people. We're all imperfect, but the idea behind the system is to make those slow, deliberate changes. All right, so that was a little shorter than the other ones, but please do come back and join us tomorrow night. We'll be doing civil liberties, which I guarantee will be much longer than tonight. So back to you, Liz.
Thank you, Paul. I'm super excited for civil liberties because that is one of my favorite things to talk about. We're so glad that you joined us tonight despite some technical hiccups. Make sure that you check below. There's review stuff. The PowerPoint that Paul used is on there, and we'll be excited to see you right back here again tomorrow. Thanks, everybody.